So as Dave said, my name is Melissa, and my research, really broadly speaking, it focuses on how a human rights perspective can change the way in which we think about drug control. Okay, and what I want to do today is I want to focus on a specific human right, and that's the human right to health. And I'm going to use an article that myself and my supervisor have recently published, which uses research from my PhD to show how human rights can offer new ways in which to think about drug policies. And the article's open access as well, so it's free to read, so feel free to read it. Okay, so why have I used human rights then? The reason why I've used a human rights perspective to provide a new perspective on drug control is because I've found there's a key tension within the drug policy field. And that's the tension that exists between a state's interest in wishing to restrict certain psychoactives and an individual's rights to consume them. And I've found that drug policy is very deeply political, and it often centres upon this core tension. Because on the one hand, we as individuals, we want to be free to have control over our own bodily integrity, our own mental faculties, to consume what substances we want, have control over our own body. But that can often act in conflict with the interests of the state, and they wish to restrict certain psychoactives, the justification there usually being on the grounds of public health or to protect the welfare of its populace. And even though there's no obvious way to go about resolving these tensions, I want to think about this issue from the perspective of human rights, and that's because I think the whole framework of human rights is really designed to address this. And that's because human rights largely centre upon this vertical relationship between states and their subjects. And not only that, they're designed to protect and respect individual autonomy, but not in ways that allow for the rights of others to be infringed. And in focusing in on this human right to health more specifically then, when I started thinking about how to go about doing my research for this article, I first started to recognise that the notion of health is an idea which has been grappled with and thought about over the centuries. And people working in this area, they tend to employ a medicalised or a social constructionist definition to try and clarify how we should think about and how we should go about understanding our health. So medicalised definitions are deterministic, and the idea of health is rooted in our biology, whereas social constructionist definitions, these believe that the meaning and the experience of illness is shaped by social and cultural systems and the environment in which we live. And I first started thinking about this at Breaking Convention in 2013, actually. And that's because I think the conference really does promote a much more holistic understanding of what health and well-being is, because you have half the speakers that do tend to embrace this more medicalised idea of health, and the other half do tend to go along with this more of this kind of social constructionist idea of what health is. So even though I think this more holistic, complete understanding of health is really necessary and important, Coggan has said that medicalised and social constructionist definitions of health can cause tension between the state and the individual, because it leads to externalist and internalist views on health. For instance, the medical establishment or policymakers tend to commit to a much more medicalised view on what they believe to be good for us, which can then lead the individual to grapple with a more social constructionist or internalist account of what they believe to be good for themselves. But in relation to substances that are categorised as illicit, there exists this strong desire to maintain the policy of prohibition. So there is often this tendency to focus on the legality of a substance to the exclusion of other concerns. And there is this tendency to adopt an externalist arbitrary view, focusing on what the state believed to be good for us. And a tendency to ignore the medical evidence which looks at the therapeutic application that various controlled substances can have, and also a tendency to ignore social constructionist internalist accounts of how any illicit substance can be useful or beneficial or have a therapeutic application for our health. And this is what happened in the leading medicinal cannabis case of Crown versus Quail and others. So what I want to do for the rest of this presentation is to analyse this case to show where the UK judiciary went wrong by adopting what I feel is an arbitrary externalist view focusing on the legality of cannabis. I'm then going to draw upon international comparisons, and finally I'm going to show how a human rights perspective can lead to an approach to medicinal cannabis use which I think facilitates a more holistic understanding of health. So Crown versus Quail then, it involves a group of cases that were heard conjointly by the Court of Appeal in 2005. And the case facts are a little bit confusing because all of these cases were heard together, so just bear with me, it's a little bit convoluted. But what happened here is all of the defendants, they suffered from a range of medical conditions, and these included, but were by no means limited to, AIDS, HIV, pancreatic cancer, multiple sclerosis and cancer, and they tried to alleviate the worst effects of their conditions by consuming cannabis. And the majority of the defendants here were convicted at trial under the Misuse of Drugs Act for either possession with intent to supply, or for cultivation. And a lot of these individuals, they wanted to challenge their original verdict and the prohibitions on their right to self-medicate with cannabis because they said that this conflicted with their human rights. And at the same time, the Attorney General was appealing a case where one original defendant, Jeff Ditchfield, was actually acquitted at his trial. And that's because the jury accepted his defence of medical necessity for supplying cannabis to multiple sclerosis and cancer sufferers. So as well as the human rights arguments that were being put forward, several of the defendants were appealing against the decision of their trial judge not to put the medical necessity defence before a jury. And the judges dismissed all of the appeals here and basically agreed with the Attorney General that the medical necessity defence is not applicable to defendants who want to supply cannabis to others. Now, I don't think I'll have time to go through the medical necessity defence, so if anybody does have any questions on how this works, just feel free to ask me at the end. But what I really want to focus on today is to hone in on this human right argument. And most of the defendants here, they argued, like I said, that the total prohibition of cannabis infringed their human rights to self-medicate. And they relied upon Article 8 of the European Convention on Human Rights to assert this claim. And this Article 8, the provision states that everyone has the right to respect for his or her private or family life. And even though the Court of Appeal held that the right to privacy in relation to self-medication at least was infringed here, they said that this infringement was justified because of the derogations that are contained in Article 8 too. And that is that you're able to limit a human right if it's deemed necessary on public protection grounds or on the grounds of public health or, say, to protect the rights and freedoms of others. But there are other grounds up there as well. But even though the Court of Appeal held that Article 8.2 applied here, there was a complete refusal to analyse the grounds upon which the Court of Appeal limited the defendant's human rights to use cannabis. So you could say that the judicial balancing exercise that the courts undertook here was really artificial. They simply just deferred the issue to Parliament. But I think this throws up some really important considerations for when a state makes a claim about protecting people. What actually is it that they're protecting? I think they're required to at least look at what was their justification for restricting these individuals' human rights. Instead, the judges just consistently made reference to the fact that they had to stick with, and I quote, the clear legislative scheme of prohibition. But by focusing on the legality of cannabis, the courts failed to account for any medical evidence. And I think this is really unfortunate because there was room for a really detailed discussion here. There were 9 instances where the Court of Appeal referred to expert evidence that was adduced from earlier judgments, and there was one really detailed discussion of the risks involved as well. And not only that, around the same time that this case is being heard by the Court of Appeal, remember it was in 2005, there were various patents being submitted by GW Pharmaceuticals looking at the therapeutic application that various cannabinoids have, one of which is now a licensed oral cannabinoid spray. It's a cannabinoid medicine called Sativex. You might have all heard of it. It's been licensed since June 2010. So given this growing pharmaceutical interest at the time and the ever-increasing literature on the medicinal uses of cannabis, for me that means that the therapeutic uses of cannabis at least warranted a discussion to more fully engage with whether the state was justified in restricting these individuals' autonomy. As well as failing to embrace a medicalised conception of health, though, the judiciary here failed to embrace a social constructionist idea of health. And that's because to really engage with the tension, I think, between states needing to restrict medicinal cannabis use on the grounds specified in Article 8.2 and an individual's right to personal autonomy, there should really have been some exploration of an individual's values and their own belief systems. Because according to Walsh, Harry and Sakharis, these should form an intrinsic part of any judicial reasoning process. And according to Charlotte Walsh as well, interfering with an individual's health choices without any sound, ethical or consequentialist reasoning can invite a really determinist response. So again, this fails to balance the binary between the state and the individual that I've been talking about. So that's the situation in the UK then. The judiciary in the UK tend to adopt this externalist idea of health, and they tend to just defer to the legality of a substance to the exclusion of everything else. I suppose the very least that can be said for the UK is that we are consistent in committing to this arbitrary approach. Across the pond, though, the situation is quite different. It's a little bit more confusing. Because since the early 1990s, medical cannabis activists have been able to exploit the legal space that exists between state and federal laws. And this started out with Proposition 215 in the early 90s and culminated in the Compassionate Use Act in California in 1996, which allowed doctors in California to recommend cannabis to their patients. Other states soon followed suit once they saw what was going on in California, and this facilitated de facto regulatory models, so informalised regulatory models, such as cannabis cooperative clubs and cannabis compassion clubs. So you can see that in the US, this started very much from a grassroots level up. And this situation left an interesting legal tension for the judiciary at both a state and a federal level. Because at times the judiciary would find in favour of the defendant and embrace this more holistic idea of health. So they would allow for the state's laws to prevail in relation to medicinal cannabis use. And that's what happened in Conant and Walters and City of Garden Grove. But at other times, the judiciary would adopt what I would call the Quail approach. So in Oakland and Cannabis Buyers Cooperative and the Gonzales-Raich cases, the courts here deferred straight to the legislature, and there was no weight given to these individuals' autonomy or the social benefits that they derived from having better access and delivery systems for their cannabis. But the tide really is turning in the US. Just last month, an amendment was passed in the Senate which said that federal law enforcement can no longer interfere with state laws in relation to medicinal cannabis. And they very narrowly lost out as well in applying those protections to recreational cannabis use. And at the moment, you currently have 23 states in the US that have legalised regulatory systems for medicinal cannabis use and 4 for recreational use. So it kind of shows, I suppose, that the walls of prohibition are crumbling in relation to medicinal cannabis use in the US at least. The situation is quite optimistic in Canada as well. And I think what the Parker and Hitzig cases show are the transformative capacity of human rights to alter the drug control regimes from the inside out. And what happened in Parker is the defendant here argued that the prohibition on his right to use cannabis to control his epilepsy was contrary to fundamental justice. And the Canadian court agreed with him. So they created legal exemptions which allowed for his medicinal cannabis use. And in Hitzig, which was heard a few years later, the Canadian applicants here argued that despite the legal exemptions that were created in Parker, which allowed for medicinal cannabis use, these applicants had no legitimate access to it. So they had these legal exemptions, but they had no way of getting hold of it legitimately. And the Ontario Superior Court agreed that this was unconstitutional. So as a result, Health Canada are now able to legally dispense cannabis. So it shows that the judicial limb really does have the potential to influence drug policies here. And I think you can see that even though the international case law has been inconsistent, a human rights lens sheds light on how formalised and informalised regulatory regimes can develop. And I think these international comparisons also expose just how narrow and rigid the UK's approach to health has been. So using a critique of the case law, I now want to finally go on to consider potential regulatory ideas for medicinal cannabis that have developed using this human rights perspective. Okay, so starting with medicalised conception of health then. Several countries now hold a licence to prescribe Bedrocan, which is pharmaceutical-grade cannabis. And it's used to treat a variety of medical conditions. And the company first started out in the Netherlands. And the cannabis here is dispensed through pharmacies in what's known as the Dutch medical model. And these pictures as well on the slides, they depict a variety of strains with differing THC to CBD ratios, depending on what works best for the individual and their medical condition. And since 2014, Canada hold a license to import Bedrocan as well. And I think this is a really positive move because I think it can address the lack of strains that have been available under Health Canada's centralised medical cannabis programme. And I also think the public health implications from having more choice can only ever be a good thing as well, because you're more adequately treating the individual and respecting their autonomy and their ability to find the strain that works best for them. But in contrast, the domestic cannabis market in the UK is saturated with a product which is very high in THC and contains virtually no CBD, what the mainstream media refer to as skunk. And from a purely legalistic, liberal perspective, I find that really concerning, because I think that it massively impacts on the choice that the consumer has here, and on an individual's autonomy to be able to find the strain that works best for them. And one of the key reasons why we don't have anything like the Dutch model and why we can't import Bedrocan is because cannabis is a Schedule I drug under the misuse of drugs regulations. So we recognise no medicinal value in the Schedule I, and cannabis is subject to the very tightest controls, which makes it really difficult for researchers to explore its therapeutic potential. And various experts and researchers have repeatedly called for cannabis to be moved from Schedule I to Schedule II at the very least, which incidentally is where diamorphine or heroin resides. And that's one of the first policy ideas that I would recommend as well. But the Home Office keep refusing. They keep just citing the same political rhetoric here that cannabis is dangerous, it's harmful, there's no medical use, etc., etc. So I'm just going to leave the Home Office logo, building a safe, just and tolerant society up there. But you might say, okay, well, what's the deal with GW Pharmaceuticals then and Sativex? Because obviously they're able to prescribe that in the UK. And without going into too much detail on how expensive this is and how much it's kind of a postcode lottery as to whether you can get hold of it or not, what the Home Office did here is they placed it in Schedule 4. And they've done this despite the fact that the product contains THC. And this hypocrisy, because it is if I can get my words out, it is an hypocrisy, it's been justified on what Professor David Nutt has termed a pharmacologically irrelevant basis, because the THC has been placed in an alcoholic solution. So apparently it's seen as being different to other forms of THC. So I think this gives you an idea then of the power and the preferential treatment that's afforded to the pharmaceutical industry and dominant healthcare systems. If we can recognise this, which I think a broader conception of health under a human rights lens allows for, then we can look at alternative ways in which to regulate medical cannabis. One of the ways that I think we can do this and account for a more social constructionist and internalist idea of health as well is to look more closely at the work of one of the original Quail defendants, Jeff Ditchfield. Now, Jeff Ditchfield, he founded Bud Buddies, and they've been illegally supplying medical cannabis for 15 years. They've been heavily influenced by scientific research which explores the efficacy of cannabis oil to treat cancer. The leading research on this is currently being conducted in Madrid. And at the moment they're trying to fund an experiment which looks at whether the whole cannabis plant or individual cannabinoids are more effective as anti-cancer agents. And for me, I think that this is really important work, because no pharmaceutical company are really going to ever conduct this, because you can't patent a plant. And on a related note as well, I want to give a shout out to Wallace Sear. I think you'll find a flyer of theirs in your bags. And I've recently been informed about this organisation, and what they do is they crowdfund scientific research that they believe to be of importance to the public. So in a similar vein to Bud Buddies and Project Storm then, they're also exploring the efficacy of cannabinoids to treat cancer. And Bud Buddies and Project Storm, they're very keen to empower individuals to be self-sufficient, to have control over the strains that work best for them in order that they get the right product. And I think this idea of empowerment is really important, because according to Anna Waldstein in her anthropological research, taking control away from the dominant healthcare systems can result in better health outcomes, since it increases the level of autonomy and self-sufficiency for an individual. So linking this back to the Quail case then, if the Court of Appeal allowed for any internalist or social constructionist considerations at all, then a more legitimate balancing act could have been conducted, which potentially looked at the therapeutic benefits of empowering individuals to make their own choices. And this notion of empowerment lends itself, I think, quite easily to a policy idea which embraces, again, a social constructionist internalist conception of health as well. And that is to potentially legalise cannabis social clubs in the UK for therapeutic use. And what we could do is we could use the very successful Spanish model as a hypothetical example, but place it within a therapeutic setting. So you could have a grower as a licensed practitioner and potentially regulate this model in a similar way to that in which complementary and alternative medicine or CAM therapies are regulated. And theoretically, at least, this model could be implemented relatively easily because it doesn't actually contravene the UN drug conventions. That's how other countries have managed to get around it, most notably Spain, who have over 1,000 cannabis social club models at the moment. Although it would require decriminalisation for possession, for personal use and for social supply. So I can appreciate that these club models are much easier, and it's much easier for them to operate in countries that have more lax laws in relation to cannabis use than it would be in the UK. But that's not to say that I don't think we should try. In the UK we have around 70 cannabis social clubs at the moment. And on a broader level, moving beyond the cannabis issue, you just have to look at the amount of psychedelic societies that are cropping up in the UK over the last couple of years. So there are regulatory models here that we can develop from the grassroots up. And just to see how successful these grassroots regulatory models are, you only really have to look at the US, what started out with Dennis Perrin and Proposition 215 in the 90s. And researchers Ryman and Lucas, looking at these compassionate club models, which started from this grassroots level, they concluded that these models offer more social, physical, mental and emotional support than the traditional pharmacy model alone. And that's because these facilities respond to the often multifaceted and complex health needs of many medicinal cannabis consumers. Ryman found that integrating social support groups, counselling and entertainment services can alleviate depression and facilitate social integration, which can be a really significant health outcome given the often compounding needs of chronically ill users. And I think this model arguably balances collective and individual interests as well, because it has the potential to alleviate the burden on the NHS, since this model is embracing a more holistic idea of health and treating these compounding health factors as well. The final policy idea that I have links back to the Quail judgment. And that's because the Quail judgment implied concern over the idea that the defendants might derive pleasure out of their cannabis use, as opposed to it solely relieving them of pain. So rather than accepting pleasure as a legitimate and a valued health outcome, which is in line with the World Health Organization's broad idea of pleasure, which incorporates this notion of complete well-being, the idea of pleasure is often neglected or frowned upon in the drug policy field. Although this is changing, researchers and commentators are increasingly embracing this idea of entheogenic therapy, and I think Ken Tupper's concept of benefit maximisation is really great as well. So we are developing our own conceptions of health and well-being here to incorporate pleasure. But in reality, I think pleasure is what motivates most of our behaviour. So it is really important to theorise a place for it, which various harm reduction initiatives around the world are starting to do. I mean, in the cannabis world, cannabis social clubs and the pharmacy regulatory models, they encourage vaping as a safer, more enjoyable, more pleasurable delivery route. And again, this alleviates public health burdens in relation to tobacco, so it balances collective and individual interests more effectively. And finally, again, in the cannabis world, there's a product called Foria, which you can get hold of if you live in California or Colorado. And it's a cannabis lube designed to enhance female pleasure. So I thought it was quite interesting. And, and I really like the ethos behind this product as well, because it says on the website, the founders, the creators of the product, the Aphrodite Care Group, believe that health and pleasure are naturally inseparable. And this idea is really important because I think it can lead us to developing regulatory policies which recognise the potential gains that cannabis and other psychoactives more broadly can have for the individual, rather than just focusing on the risks or harms. And that would allow policymakers to move beyond prohibitionist constructs, which constrain us so much at the moment. So to conclude then, through employing an arbitrary, externalist idea of what is good for our health, I think the Quail case and some of the international case law has demonstrated that judges have been unwilling to consider the significance that cannabis holds for the individual. And I've used cannabis case law and the human right to health as conceptual tools to try and give you a more detailed insight into how human rights can address the power dynamic between the state and the individual if we allowed for a broader idea of what our health could be. And finally, I think by drawing these parallels between the state and the individual, human rights can embrace a broader idea of health in a way that reflects the many different contexts for human drug use, and also in a way that doesn't depoliticise drug policy. Instead, I want to use human rights to open up a dialogue to think about drug policies in a more thoroughgoing and potentially radical way. Thank you. Thanks.